Hello everyone, welcome back to Madad IAS. This is video 13 of direct sources of each questions asked from polity in UPSC CSE in the last 20 years, specifically from the book Laxmikanth, which is our main source of preparation for polity. Here you will find marked chapters and page number wise questions. The screenshots are attached here as well. If you don't know what we're doing here exactly, I would request you to go to the 2005 video in this series. But just to give you a brief, what I've done here is I have marked all the questions that have been asked in UPSC CSE 2017 here. So you can go ahead and do something similar in your books as well, so that whenever we are studying polity, at least we do not miss out on the parts that have already been asked. So whenever a question repeats, a lot of time themes repeat and not the question itself, and we at least revise the parts which have been asked in UPSC. Now, without further ado, starting with the first question from 2017, the topic is preamble. Which of the following objectives is not embodied in the preamble to the Constitution of India? Out of all these four options, we find this particular answer in chapter 5, preamble, page number 42 in the 7th edition of Laxmikanth. Very specifically here you can see that the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. So here we can see there's liberty of thought, there's liberty of expression, and there's liberty of belief. What we don't have is economic liberty, that's just for justice. So answer becomes B. This is not mentioned in the preamble to the Constitution of India. Coming to question number 2, we have again same topic. The minds of the makers of the Constitution of India is reflected in which of the following? Answer is preamble. We find this in chapter 5, page number 46. The preamble embodies the basic philosophy and fundamental values, political, moral and religious, on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding fathers of the Constitution. So very clearly the answer is A here. Coming to question number 3, the topic is fundamental rights. Which of the following are envisaged by the right against exploitation in the Constitution of India? 4 options are given: prohibition of traffic in human beings and forced labor; 2, abolition of untouchability; 3, protection of the interest of minorities; 4, prohibition of employment of children in factories and mines. Now here very clearly we can look in chapter 8, chapter 8, which is the fundamental rights chapter. While it is given in the chapter itself, but it's easier to kind of look at it from the table. So we turn to page number 106, table 8.8. Now here under right against exploitation, the rights are given: 23, prohibition of traffic in human beings and forced labor; prohibition of employment of children in factories. So 1 and 4 become correct. Point number 2 is abolition of untouchability is a right under right to equality, Article 17 of the Constitution, and protection of the interest of minorities comes under cultural and educational rights under Article 29 and 30. So answer becomes 1 and 4 only. Coming to question number 4, the topic is again fundamental rights. Which of the following statements is or are correct? Rights are claims of the state against a citizen. Rights are privileges which are incorporated in the constitution of a state. Rights are claims of a citizen against the state. Rights are privileges of a few citizens against the many. Now, if you can see directly, D is incorrect, right? Our answer is majorly between like the other options that are given. Now let's read from chapter 8, fundamental rights, page number 74. The fundamental rights are meant for promoting the ideal political democracy. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against invasion by the state. They operate as limitations on tyranny of the executive and arbitrary laws of the legislature. Now from this we can see that they are not privileges and they are also not claims of the state against the citizens. They can and they fit the definition very well of being the claims of the citizens against the state, as they are also limitations to the tyranny of the state. So our answer becomes C. Rights are claims of citizens against the state. Coming to question number 5, the topic is fundamental duties. Which of the following statements is or are true of the fundamental duties of an Indian citizen? First, a legislative process has been provided to enforce these duties. They are correlative to legal duties. Now, we can find this answer in chapter 10 on page number 120, features of fundamental duties. Like the directive principles, the fundamental duties are also non-justiciable. So they are non-justiciable, so they don't have a legislative process to enforce them. The Constitution does not provide for their direct enforcement by the courts. Moreover, there is no legal sanction against their violation. However, the preamble is free to enforce them by suitable legislation. Now, what it means here is that there is not like a set legislative process for this to be provided like for these. We can pass on certain like laws to actually enforce these fundamental duties, but it's not done in a way where all the fundamental duties are enforceable directly, right? They're non-justiciable in nature, and they are not correlated to legal duties, as they have no legal sanction directly. Coming to question number 6, again the same topic, same chapter, page number 119. In the context of India, which of the following is correct relationship between rights and duties? Rights are correlative with duties. Here we can see through the rights and duties of citizens are correlative and inseparable. The original constitution contained only the fundamental rights and not the fundamental duties. What this means is that fundamental duties were later added, but they are correlative to rights. So here answer A becomes correct. B is just an absurd statement. Rights are personal and hence independent of society and duties. Rights, not duties, are important for the advancement and personality of the citizen. Duties, not rights, are important for the stability of the state. All three statements are a little bit absurd as well. So these are not the answer. The answer is only A. Coming to question number 7, the topic is DPSPs. Which among the following were added to the directive principle of state policy by the 42nd Amendment to the Constitution? We can go to chapter 9, DPSPs, page number 110 and page number 109. Here we can directly see that the new directive principles which are added by the 42nd Amendment of 1976 are given here. Just a second. Yeah. To take the steps to secure participation of workers in the management of the industries, Article 43A. So this becomes our correct answer. And for the other A, C and D, we find them on page number 109. So 2, 4 and 6 are the original, like one of the original DPSPs, and this one was added later on. I'm not going to read this entire thing. You can go ahead and read this because DPSP is a chapter we do in a lot of detail. So I don't think we should spend a lot of time here in this question. Coming to the next question, again the topic is DPSPs. With reference to the Constitution of India, the DPSP constitute limitations upon. Now, what do they constitute limitation upon? Now, we know that they're non-justiciable in nature. So, they don't directly put limitations upon anything. Like, they do not put, limitations on legislative function or the executive function. So, answer here is neither 1 or 2. We can find this answer in page number 112, where you can see, okay, so it's also in page number 111, second paragraph, and then also in page number 112. Though the directive principles are non-justiciable, the Constitution makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Thus, they impose a moral obligation, but the real force behind them is political, that is public opinion. Again, in the criticism of directive principles, we can see under point number 1, no legal force. The directives have been criticized mainly because of their non-justiciable character. So, they basically do not have any sort of legal sanction directly per se. Coming to question number 9, the topic is legislative assemblies. Sorry, that I think this is just written, I meant Lok Sabha here. The chapter is 23, Parliament, on page number 226. For election to the Lok Sabha, a nomination paper can be filed by anyone residing in India, a resident of the constituency from which the election is to be contested, any citizen of India whose name appears in the electoral roll of a constituency, any citizen of India. Now to check the answer for this, we go to page number 226. Here we just have to check the constitution lays the following qualifications for the person to be chosen as a member of parliament. He she must be a citizen of India. He she must make and subscribe to an oath affiliated before the person authorized for the election commission for this purpose. He she must be less than 30 years of age. He she must possess other qualifications prescribed by the parliament. As per the Representation of People Act 1951, it is said that he she may be registered as an elector for the parliamentary constituency. For a parliamentary constituency, this is same in the case of both Rajya Sabha and Lok Sabha. The requirement that the candidate contesting in election to the Rajya Sabha from particular state should appear to be an elector in that particular state was dispensed or removed in 2003. So B is incorrect. A also becomes incorrect because it has to be a citizen of India. Out of C and D, the better one is C because it satisfies both the conditions, that must be a citizen and the name should appear in an electoral roll of a constituency. D could have been correct if this point of electoral roll of a constituency was not given here. So the more correct answer here becomes C. Coming to question number 10, the topic is again from the chapter Parliament, chapter 23. The question is, consider the following statements. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Okay. According to the provisions laid down in the Constitution of India, in Lok Sabha, the Speaker's post goes to the majority party and the Deputy Speakers to the opposition. Now, this is talked about a lot in any sort of tricks videos, that anything which says that according to the Constitution of India, according to the provisions of Constitution of India, has to be read very carefully. So we are going to read very carefully, right? Now, here we can see that under the first past the post system, though the Constitution has adopted a system of proportional representation in the case of Rajya Sabha, it has not preferred the same system in the case of Lok Sabha. Instead, it has adopted the system of territorial representation, first past the post system, for the election of members to the Lok Sabha. Under territorial representation, every member of the legislature represents a geographical area known as a constituency. From each constituency, only one representative is elected. Hence, such a constituency is known as a single-membered constituency. In this system, a candidate who secures a majority of the votes is declared elected. This simple majority system of representation does not represent the whole electorate. In other words, it does not secure due representation to minorities and to smaller groups. Again, we come to page number 232. Usually, the speaker comes from the ruling party, while the post of the deputy speaker goes to the opposition party. However, there have been certain exceptions in this regard. The speaker and the deputy speaker, while assuming their office, do not make and subscribe any separation or oath. Okay. Usually, so here you can see that usually the speaker comes from the ruling party, while the post of deputy speaker goes to the opposition party. There have been certain exceptional cases. So that means this has not particularly been laid down in the Constitution, and this becomes an incorrect, right? Now, for the first statement, we can see that it doesn't matter that the candidate must get at least 50% of the votes polled. It can be 40, 20, 20, right? Whoever gets the most percentage of votes, they win. It does not have to cross the 50% mark. So this also becomes an incorrect statement. The answer becomes D, neither 1 nor 2. Coming to question number 11, the topic is fundamental rights. Chapter is chapter 8, fundamental rights, page 106. Right to vote and to be elected in India is a. Now, on page number 106, rights outside part 3. So here you can see there are certain fundamental rights included in part 3. There are other rights contained in other parts of the Constitution. These rights are known as constitutional rights or legal rights or non-fundamental rights. So as we know that right to vote is not necessarily given in fundamental rights, so they are not a fundamental right. They are a constitutional right. So they are given here as the rights outside part 3. I hope it is clear. Coming to question number 12, the topic is Election Commission, Chapter 43, Election Commission. The question is, consider the following statements. The Election Commission of India is a 5-membered body. 2. Union Ministry of Affairs decides the election schedule for the conduct of general elections and by-elections. Election Commission resolves the disputes retaining to splits, mergers or recognized political parties. Now, particularly, we find this answer in page number 420 and 421. Very clearly, it is given here that the Election Commission has been functioning as a multi-membered body consisted of 3 election members. So, it's not 5, 1 becomes an incorrect. The Election Commission of Service of, the Election Commission Act of 1991 contains the following provisions. The Chief Election Commissioner and the 2 other election commissioners shall have equal powers and receive equal salary allowances and other prerequisites which are similar to those of the judges of the Supreme Court. Now, in page number 421, it's very clearly given that Election Commission notifies and the dates and schedules of elections and to scrutinize the nomination of papers. I think I have missed this post here. It is given in this particular page itself as per my understanding. Here answer 3 is correct and it is given here. Okay, so sorry. I think I am getting a little bit confused. Okay, so point number 2, Union Ministry of Home Affairs decides the election schedule for the conduct of both general and by-elections. No, they do not. The Election Commission notifies the date and schedules of elections and to scrutinizes the nomination papers. So statement 2 also becomes incorrect and statement 3 is correct. This is given in the book. I have forgotten to attach a screenshot here. Coming to, so the answer becomes only 3, D option. Coming to question number 13, the topic is state emergency. The chapter is chapter 7. Okay, coming to question number 13, topic is state emergency. The question is, which of the following are not necessarily the consequences of the proclamation of the president rule in a state? Not necessarily. We have to make sure not to miss these keywords like are, not. 1. Dissolution of state legislative assembly. 2. Removal of council of ministers in a state. 3. Dissolution of the local bodies. So they're asking us what happens in a proclamation of president rule and what does not happen here. Answer here is 1 and 3. We'll see how it is correct. Now when we check in chapter 17 emergency provisions under page number 179, point number 1 is incorrect because it can suspend the state legislative assembly, not just dissolve, and nothing about the local bodies is given in this particular article. Let's read up this paragraph. Consequences of president rule. The president acquires the following extraordinary powers when the president rule is imposed in a state. He/she can take up the functions of the state government and power vested in the governor of any other executive authority in the state. He/she can declare the powers of the state legislature are to be exercised by the parliament. He/she can take all the necessary steps, including the suspension of the constitutional provisions relating to any body or authority of a state. Therefore, when the president rule is imposed in a state, the president dismisses the state council of ministers headed by the chief minister. The state governor on the behalf of the president carries on the state administration with the help of the chief secretary of the state on the advisors appointed by the president. This is the reason why a proclamation under Article 356 is popularly known as President's Rule in a state. Furthermore, the president either suspends or dissolves the state legislative assembly. Now, it's not definitely that, the state legislative assembly will just get dissolved. It can also get suspended. So 1 becomes incorrect. 3 is not given anywhere in this Article 356. Nothing about local bodies is given. But yes, 2 does happen. The Council of Ministers just gets dismissed and the state governor on behalf of the president carries on the state administration. So answer here becomes B only, 1 and 3. Coming to question number 14, the topic is federalism. Which of the following is not a feature of Indian federalism? There is an independent judiciary in India. Powers have been clearly divided between the center and the state. The federating units have been given unequal representation in the Raj Sabha. It is a result of an agreement among the federating units. Now, if we have read chapter 14, Federal System, under page number 138, the Constitution of India provides for a federal system of government in the country. The framers adopted the federal system due to two main reasons: the large size of the country and its social cultural diversity. They realized that the federal system not only ensures the efficient governance of the country, but also reconciles national unity and regional autonomy. However, the term federation has nowhere been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of states. The phrase union of states has been preferred to the federation of states to indicate two things. One, the Indian Federation is not the result of an agreement among the states like the American Federation. Two, the states have no right to cede from the federation. The federation is a union because it is indestructible. So now if you look here in terms of federalism, D is incorrect because this is not a feature of Indian federalism. This is a feature of the American federalism. And these other 3 points have been given in this chapter and they are absolutely correct. Coming to question number 15, the topic is Panchayati Raj. Local self-government can be best explained as an exercise in democratic decentralization. Anytime we read this chapter, chapter 39, Panchayati Raj, it's given here on the very first page itself. Page number 389, Evolution of Panchayati Raj System. Here you can see the word democratic decentralization in reference to Panchayati Raj. Coming to question number 16, the topic is Parliament. Chapter 23, page number 240 and 242 give us this answer. The chapter is parliamentary. The chapter is Parliament. The Parliament of India exercises control over the functions of the Council of Ministers through adjournment motion, question, or supplementary motion. It is just asking how the Parliament is exercising its control over the Council of Ministers, and all these three are a part of devices of parliamentary proceedings. Question R is also here. Start questions, adjournment motion, as well as supplementary questions are a part of different proceedings, different devices of parliamentary proceedings. So all three are correct here. Coming to question number 17, the topic is Parliament. Chapter 23, page number 245. Now here the second point is not necessarily in the book given, like it's not directly given in the book. Like first private members bill has been passed recently in the Parliament for the first time in the history of India. This is an incorrect statement because the first private members bill was passed in the 1950s itself and not in like the recent past of 2017. So this is an incorrect statement. Regarding the first statement, a private member's bill is a bill presented by a member of parliament who is not elected but only nominated by the president. This is not the definition of private member's bill, as we can see from table 23.3 on page number 245. A private member bill is a bill introduced by any member of the parliament other than a minister. So any other member of the parliament can introduce a bill who is not a minister, and that is going to be called as a private bill, not necessarily by nominated members of the president. So answer becomes D, neither one nor two. Coming to question number 18, again the topic is parliamentary systems. We come to chapter 13, parliamentary systems. The main advantage of parliamentary form of government is that the executive remains responsible to the legislature. Now this is something that is repeated over and over again when we start reading all of these topics. But here necessarily in chapter 13, page number 131, Ivor Jennings called the parliamentary system as a cabinet system because the cabinet is the nucleus in a parliamentary system. The parliamentary government is also known as responsible government, as the cabinet is accountable to the parliament and stays in office as long as it enjoys the latter's confidence. So the answer here is C, the executive remains responsible to the legislature, which is the most appropriate answer for the main advantage of parliamentary form of government. Coming to question number 19, out of the following statements, choose the one which brings out the principle underlying the cabinet form of government. Again, this is going to be similar and the same as the last question. This collective responsibility point is given in this chapter, again like same chapter, chapter 13, page number 131 and 132. Collective responsibility. The bedrock principle of parliamentary government, the ministers are collectively responsible to the parliament in general and to the Lok Sabha in particular, which is also the Article 75 of the Constitution. So here the answer becomes very clearly answer C, a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Coming to question number 20, In India, the judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, the power of judiciary to question the wisdom of the laws enacted by the legislatures, the power of the judiciary to review all the legislative enactments before they are assented to by the president, the power of the judiciary to review his own judgments given earlier in similar or different cases. Now, C is just not correct. There is no such power that they can happen before the assent of the president. This is also like a little bit of an absurd statement. A and D are correct statements, but judicial review necessarily tells us the power of the judiciary to pronounce upon the constitutionality of laws and executive orders. D is another power of the judiciary, which is given under page number 293 in chapter 26. We can read here very clearly. Point number 6, you can see judicial review is the power, like exact same line is given here. And in the review jurisdiction, point number 7, the Supreme Court has the power to review any judgment pronounced or made by it. A review petition has to be filed within 30 days from the date of the judgment or the order sought to be reviewed. Also, the review petition should be submitted to the same judge or bench that delivered the judgment or the order. So our answer becomes A here. Coming to question number 21, this particular question is not in Lakshmikanth. Democracy's superior virtue lies in the fact that it calls into activity the intelligence and character of ordinary men and women. I think this is from NCERT, but I'm not very sure. This is the most correct answer out of the 4 options given, because as we have universal adult franchise and everybody gets to vote, right? So this becomes the superior virtue of democracy. B, C, and D do not really fit well with this particular statement, because it's not a method to strengthen executive leadership. It's not about superior individuals with dynamism and vision, and it is not for like a band of dedicated party workers. Coming to the last question, the topic is fundamental rights. One of the implications of equality in the society is the absence of privileges. Here in chapter 8, just a second, I think the video is getting buffered a little bit. Coming to the last question of this particular video, the topic is again fundamental rights, chapter 8. We can find the answer in the page 177. One of the implications of equality in a society is the absence of privileges, restraints, competition, and ideology. Now, C and D do not make sense here at all. Competition and ideology will always be there. In terms of A and B, we can still get confused, but let's read from page number 77. Right to equality, equality before law and equal protection of law. Article 14 says that the state shall not deny any person equality before the law or equal protection of laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal person via statutory, corporations, companies, registered societies, or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a absence of any special privileges in favor of any person. So this gives our answer that one of the implications of equality in society is the absence of privileges. We are at the end of the video. This was a relatively longer video. I hope this helps. I'm going to be putting all the PDFs in my Telegram channel. You can find that in the link below. Thank you.